Well, good morning, everyone. Let's begin. It's 11 a.m. I'm Anita Huberman. I'm CEO of the Surrey Board of Trade. And thank you for virtually attending the Surrey Board of Trade Surrey Digital Town Hall Series. Today, we're focusing on immigration bans and travel bans in both Canada and the United States. And as you know, Surrey is a border city with the greatest number of manufacturers in British Columbia, contributing to global and national supply chains. And so this is a very important topic, not only for Surrey, but for all of Canada. Still, it's important to acknowledge at this time that we are on the unceded territory of the Coast Salish peoples, specifically the Kwantlen, Katzie, Semiahmoo, and Tsawwassen First Nations. I'd like to thank, first of all, the Port of Vancouver for sponsoring the Surrey Digital Town Hall Series. Without sponsorship, Board of Trade events simply could not take place. And a big shout out to the Port of Vancouver, our frontline workers, for ensuring that all of our supplies, the things that we need in our day-to-day lives, are there for us, such as our marine pilots, our terminal workers, our truck drivers, and our railroaders, all contributing to the dynamism of the Port of Vancouver. Thank you again. Just a couple of instructions before we begin. The session is being recorded. The link will be sent to you after the session is over. A survey will also be sent to you just to acquire some of your feedback on the session. And please put your question in the chat function. We'll get to the questions as soon as we possibly can. We have some presentations by our facilitators, some prepared questions that we've received in advance and have been receiving since the beginning of this pandemic. At the Surrey Board of Trade, we are getting questions daily from our members, from the business community in general, because of our unique connections to government. Our facilitators this morning are going to lead us through two presentations. We have 1 hour and it's going to go by very quickly. The first is on immigration bans and travel bans in Canada, followed by the second on the same topic in the United States. And I just wanted to also mention that the facilitators in this format are just providing information. They are not providing legal advice. You can certainly contact them after the session is over, and the contact information for the facilitators will be sent to you also after the session and is in the chat function right now. I'd also like to encourage you to visit the Surrey Pandemic Business Center portal on the Surrey Board of Trade's website, businessinsurrey.com, with all of the most up-to-date information there to support your business, your organization. And of course, yesterday, we heard from British Columbia's Premier on the framework of how we are going to restart the economy. And of course, it's not all perfect and a lot of clarity is still needed, but it is a beginning. And really under these uncertain conditions, there's going to be more clarity to come. I want you to know that the Surrey Board of Trade itself is on the Premier's Economic Recovery Task Force. We meet weekly with the Premier and relevant ministers to identify gaps and opportunities during the pandemic and now post-pandemic to ensure that our economy is the best that it can possibly be in Canada, and also to ensure that Surrey is an opportunity city. And I wanted to also let you know that the City of Surrey Pandemic Team meets weekly with the Surrey Economic Recovery Task Force, which we formed and announced last week to really support businesses. And that is a coalition of BIAs, chambers, and the Surrey Board of Trade. And federally, we have a line right into the Prime Minister's office and also into two different relevant ministries to also support businesses, identify gaps, and be your concierge of connections. So everyone, let's begin. So to introduce our panelists, first of all, we have Jae-Yeon Lim. She's an associate at Fasken Martineau DuMoulin LLP based in Vancouver, and Fasken itself is a sponsor of the Surrey Board of Trade's Business and International Trade Center. Jae-Yeon practices exclusively, ladies and gentlemen, on Canadian immigration law and represents employers from a diverse industry base, as well as individuals and families seeking temporary and permanent relocation to Canada. In her day-to-day practice, she facilitates the mobility of individuals from other countries to Canada. Our next facilitator is Ieva Aubin. She's a partner at Dorsey Whitney in Seattle. She counsels employers in all aspects of the employment relationship, including navigating the U.S. immigration system to help businesses grow and succeed. Ieva advises corporate and individual clients on all aspects of U.S. immigration and nationality law, including non-immigrant visas, permanent residence petitions, citizenship and naturalization, and so much more. Both of them are going to offer a wealth of experience to you on this very important topic, important to Surrey's economy. So now I'm going to pass the floor, so to speak, virtually over to Jay. Please go ahead.
Hi, everyone. Thank you very much for the introduction, Anita. So I just want to make sure that you can see my screen. So this is a very relevant topic right now. I'm sure many of you have heard about all these different changes that are coming up and that are affecting a lot of people that are non-Canadians and non-Canadian permanent residents. It has been in the news, and I have to say, as an immigration lawyer, this is like the twilight zone in immigration law. As I've been counseling many of my clients, the law changes almost on a daily basis, and sometimes my legal advice that was dispensed the week prior has to be updated because of the many things changing. That said, I have tried my very best to update my presentation today based on the state of the law as of today, but just to let you know, this information may very well become outdated. You know, for example, next week, who knows what will happen, but I do hope that it'll give you some general idea of what you can anticipate at this time. I would like to just introduce myself. Again, Anita, thank you very much for that introduction. So just to give you a little bit of brief synopsis about me, my name is Jae-Yeon Lim. I go by Jay. I initially came to Canada as an immigrant, but I speak French, Korean, and English. I graduated from the McGill Faculty of Law, and I've been exclusively practicing in the immigration law only since 2014. And the reason why I volunteer a lot, so I'm currently sitting on the national executive on the national immigration section. And the reason is because in order for me to do a good enough job for my clients while I'm practicing exclusively immigration is because I need to be fully up to date with these changes. And what we do as part of the CVA executive is that we regularly go to the policymakers and provide them with their recommendations for these proposals. So in fact, the last couple of weeks since March, when all these changes started coming up, is we've been quite busy in our executive to discuss these changes with the government and provide them with our feedback. And the government has been quite gracious in listening to our input. And in fact, just this week we had the CBA executive, we had a televised interview with Minister Mendicino. So again, the ongoing collaboration and communication has been quite frequent since the changes have been happening. And we have been advised that the Canadian government is fully aware of how this is impacting everyone. So again, we do hope to see better things coming up while these travel bans are in place. So today I will talk about three things. Mainly, I will first start off with the travel bans and what the exemptions to the travel bans are. And then I will talk about the impact of the COVID-19 policy on the current immigration processes. And then finally, I will leave with some tips for the BC employers. As I understand, many of the Surrey businesses are impacted by these changes. So we hope that we can give you some top tips that I can leave you with in this presentation that will be of use. So there's a number of changes that have happened since the travel bans and all these different legislation have been announced by the federal government on the 18th of 2020. So the two main things that have happened are the Quarantine Act and the Aeronautics Act. So on March 18th, the Government of Canada announced travel restrictions that was pursuant to its powers under the Quarantine Act and the Aeronautics Act. What it does is that it banned foreign nationals entering from all countries except USA from entering Canada, with very few exceptions. Anyone boarding a flight to Canada now must undergo a health check and is not permitted to board if they exhibit any symptoms of COVID-19. Also, the Canadian government has centralized the ways in which they screen the foreign nationals that are coming to Canada. So what it does is that it's redirecting international flights to one of the 4 airports: Vancouver, Calgary, Toronto, and Montreal. And these larger airports have the facilities and the training to do the further screening for the foreign nationals. Travelers that are travelers are prohibited from crossing the Canada-USA border for non-essential travel. I will go further into that detail later in my slides. And of course, exceptions apply to that, such as trucks that are crossing borders that are providing us with the supply chain here in Canada that are of critical importance for the Canadian infrastructure and supplies. Furthermore, all travelers that are coming to Canada must undergo 14-day mandatory quarantine period, for the most part, with very few exceptions. And in another additional requirement that has been introduced just recently is that people that are coming back to Canada must provide the border agent with their quarantine plan. So what's required for that plan is that they will have they have to satisfy the officer that they will have safe means to go to an accommodation and stay there for 14 days, that they have means of supplying themselves with basic necessities for those 14 days, and that there's no one who is in that accommodation that is vulnerable. So all those things are now affecting and obviously impacting people's abilities to come to Canada for travels. And then it's important to just note, though, that this has all been a temporary measure. It's not intended to be permanent. And if you look under the coronavirus 19 policy page on the IRCC website, it in fact has an expiry date. Of course, this is extended to a certain period of time, and it has been extended up until now, since this all started being implemented in mid-March. So we will likely see this being extended until the government announces that they will return to normal, what that new normal means. Sorry, I'm just going to the next slide. So now let's talk about who's allowed to Canada and who's not allowed to Canada. So under the travel restrictions, it distinguishes 2 types of groups. So for people that are coming from any country other than the United States, in order to come to Canada, they need to be first covered by the exemption in the order, and they must demonstrate that they're not coming here for non-optional, that they are traveling for non-optional and non-discretionary purpose. For people that are coming from the United States, they have to satisfy the BSO Border Services officer that they're traveling for non-optional and non-discretionary purpose. How do you know whether your travel is optional or discretionary? Now, it's not really clear-cut, and this is where our CV executive has been most active, is that we've been indicating that there's a lot of inconsistency, which is something I will also talk about later in my slides, but the way the orders in council are laid out, and also the way the law has been implemented, at the borders and ports of entry, has been quite inconsistent. But generally speaking, what is no longer permitted is coming to Canada for purposes of tourism, recreation, and entertainment, obviously, because these are not essential. And also discretionary or optional travel includes things like visiting your family for vacation, coming to Canada to see your family member, for example, your extended family, coming to see your family or visit your cottage or second home in Canada. That's also no longer allowed. And believe it or not, even coming to Canada to attend the funeral of a family member is also considered discretionary travel. So you can see that these are usually life events that are usually, if it was a normal kind of circumstance, people should be allowed to come to Canada, no problem. But because we're in emergency and this is in the middle of pandemic, they're really limiting the extent of travels that are allowed for people that would otherwise be allowed to Canada. Purposes that are considered non-optional and non-discretionary include things like providing services, economic services, and services that will be impacting the supply chains in Canada, providing support that have to do with critical infrastructure in Canada, anything that has to do with the health, safety, and security, for example, providing immediate medical care, supporting Indigenous communities in Canada, also anything that has to do with the government in Canada saying that this is critical to Canadian critical supplies or health and safety, then that will be considered non-optional, non-discretionary. I will also talk about this later as well. So as you can see, there's a wide range of things that can impact how the officers will view the purpose of your travel. Also, just to note, the people that are exempt, for people that are not US citizens but seeking to enter Canada, people that are, there's a whole list of people that are still allowed under that are considered exempt from the travel ban. So people that are temporary foreign workers who have either a work permit or work permit approval, international students who have been approved for their studies in Canada on or before March 18th, immediate family members of Canadian citizens or permanent residents, and immediate family members that have already received their approval from the government of Canada to come to Canada for the purposes of family reunification. There's a couple more, but I'm just mentioning the ones that are most salient. Now, the difficulty with these exemptions is that they still have to undergo the test of essential, non-essential travel. And that's where it becomes a little bit dicey. There was an unfortunate story that I just read this morning about a pregnant Canadian citizen who works as an IT worker in New York, who was unable to unfortunately come with her husband to Canada because the border agent was of opinion that she was coming to Canada with her husband to give birth here in Canada to be non-essential, which is unfortunately, again, going to show you that there's a huge discrepancy between what's actually in the order in council and what's being implemented at the border. So again, these are some typical consistent challenges that I'm seeing in my daily practice of immigration law. There's a little bit of, quite a bit of back and forth between ports of entry and also because the CBSE officers have different ideas what it means to do essential work. Also, another difficulty is that normally people that were able to obtain their status documents at the border no longer are able to do so because flag pulling is no longer permitted. What they're trying to do is they're really trying to reduce the amount of volume and the work that normally these border services officers were undertaking and processing. So for example, people that had, that were confirmed permanent residents that were coming for landing appointments at the border, again, these landing appointments have been canceled. So these are things that are impacting the processing and also causing the delays internally for these ongoing applications. But also it requires that people are, prepared in advance. So if they're outside of Canada now, they have to be prepared to go through a very difficult process to come back to Canada, knowing that it's a risk even if they are allowed to come to Canada because they're exempt under the travel ban, they still have to undergo this very elusive test of essential, non-discretionary, non-optional travel. Again, it's very, very difficult to assess sometimes how that means without knowing the specifics of the details. But I think that this is also, it's good to keep in mind that these things are affecting a lot of people right now. I just have 8 minutes. I'm just going to quickly go over some of the top tips for BC employers at this very difficult time. So one thing that I've been seeing widespread is that a lot of businesses are impacted understandably by the current ongoing pandemic, and also because businesses had to close due to the mandatory closure requirements. I would just caution that if temporary foreign workers are employed at your organization, and if there's been any changes in conditions in terms of their employment, and these are employer-specific work permit holders, so what that means is they have work permits, and at the top of it, it has your organization's name, for example, then I would just caution you from making changes without seeking legal counsel, just because you want to make sure that it doesn't cause or trigger any employer compliance issues. Especially if you're planning to hire them back after the temporary period. Again, this is something that you want to just double check. Things like salary reduction and reduction in work hours are definitely things that would and likely cause employer compliance issues later if you are audited by random inspection for making sure that you've been compliant with the terms and conditions of the work permit. And this is something that could happen to employers that employ foreign workers based on that employer-specific work permit for a period of up to 6 years, commencing from the date that the foreign worker has started work. So again, it's very important to just make sure that you get the proper legal advice, to make sure that you are being proactive and that you prepare in advance. Another thing to note is that if they are laid off, or if there's any variations to the conditions of their work, for example, reduction in work hours, that can also impact their ongoing, for example, PR applications. So for example, the conditions of the nomination from the province may be impacted if, for example, if they're laid off, then they may no longer qualify to be nominated by the province. So it's important to double check how that will impact the foreign worker individually as well. And then also, just proactively speaking, if you're planning to send or hire or continue to retain the foreign worker, I think at this time, even though the law is not quite clear-cut, it's also good to be proactive in terms of examining how your business and how that foreign worker meets the essential purpose test. In terms of the essential purpose, I mean, anything that can help the Canadian government to, for example, provide essential functions in healthcare or critical infrastructure, supply of food, and any other critical goods. If that argument could be made in terms of not only your industry, but also what that foreign worker will be actually doing, that could be again, that could be something that would strengthen their case if possible. So again, these are some things that I thought I could put together at this time, again, knowing that this could change at any minute. But thank you again for your patience with me. I know this is a lot of information, and if I'm unable to answer all your questions today, feel free to get in touch with me. And I will now turn over this presentation over to Ieva for the overview of immigration and travel bans in the States. Thank you.
Thank you so much. Eva, over to you.
Good morning, everyone. Thank you for joining us for this very timely discussion of the implications of COVID-19 on US immigration. My name is Ieva Aubin. As Anita mentioned, I'm an attorney at Dorsey & Whitney. I'm based in Dorsey's Seattle office, and I'm a member of Dorsey's Employment and Business Immigration Group. And together with my colleagues, I regularly advise clients on all aspects of U.S. citizenship and immigration law. Just like Jay, I'm a foreign national myself. I'm originally from Lithuania, and I have firsthand experience with various non-immigrant and immigrant visa classifications, ranging from F1 student to J1 exchange scholar to H1B worker to green card holder. So when I first graduated from law school and joined Dorsey over a decade ago, I was naturally drawn to the area of immigration law because it was close to my heart. And I always was fascinated by it. And then since then, I've truly enjoyed assisting US employers and individual clients on how to navigate this really complex US immigration law system. So here's a slide on my background. Introduction and overview of our agenda. Today I'm going to talk about the current status of international travel bans and consulate closures in the US. I will also talk about the developments at the US-Canadian border and touch on other updates from the Custom and Border Protection Agency, or the CBP. Then I will focus on the developments when it comes to the US Citizenship and Immigration Service. This is the agency that is part of the Department of Homeland Security in the US that is sort of the primary benefit granting branch of the Department of Homeland Security. If you need to sponsor for a national for a work visa or green card application, you're dealing with the US Citizenship and Immigration Service. Finally, I will share some of the tips for cross-border travelers and their employers. So just like in Canada, immigration-related news in the US has been making headlines nearly daily. We've seen many developments and things tend to change by the hour. I'm sure many of you have seen some of the major headlines coming from the US when it comes to immigration. For example, back on April 20th, President Trump tweeted late on Monday night that in light of COVID-19 and in light of the need to protect the jobs of American workers, that he would be signing an executive order essentially suspending what many perceive to be all immigration into the United States. As you can imagine, that announcement sent many of our clients into a panic mode, so to speak, and really was quite concerning to many of our current and potential clients. And President Trump did sign a presidential proclamation a couple of days later. It was released on April 23rd, I believe. But the scope of the presidential proclamation that was finally issued was actually quite limited. It wasn't as far-reaching as initially was thought, or at least as one could have perceived just looking at the president's tweet. What the proclamation does, it effectively suspends the issuance of immigrant visas at the US consulates abroad for a period of 60 days. Immigrant visas is another term for green cards. So essentially, right now, you're not able to get your green card through the so-called consular process for a period of 60 days. Speaking in practical terms, this presidential proclamation really didn't change that much because consulates are already closed. They've been closed for weeks. And that, combined with international travel restrictions and the reduction in international flights, really makes it very difficult for many foreign nationals not only to process visas but also just travel to the United States. So again, the practical effect of the presidential proclamation was quite limited, although it does, its tone and the general statements from administration, they do signal that we may see additional changes when it comes to work visa programs into the US in the coming months. So what are some of the key developments, other key developments related to immigration into the US. What I'm gonna do, I'm gonna discuss those developments as they relate to the key government agencies that impact those developments. So the Department of State is a government department that essentially operates US consulates and embassies abroad. And if you have a need to obtain a US visa stamp, or you have a worker who needs a US visa stamp, then you're dealing with the Department of State through the consulates and embassies abroad. As you know, many Canadian citizens are actually exempt from visa, from the need to obtain a visa stamp prior to traveling to the US in certain categories. So for example, if you're going to the US as a visitor for business or pleasure, you are entering essentially in what's called the B1, B2 visitor category, and you do not need to visit a consulate prior to visiting the US for this purpose, because you are exempt from the need to have a visa. Other individuals from other countries, you know, they're not exempt, so they need to make that appointment. And of course, the difficulty is that all consular processing is currently suspended until further notice for routine visa issuance. I should mention that Canadians do require visas if they want to enter the US in the E1 or E2 category, for example. E1 is the treaty investor visa. E1 is the treaty trader, and the E2 is treaty investor visa. So if you are hoping to get such a visa or currently have such a visa and need to renew it, then you, of course, you're impacted by this consulate closure. US consulate and embassies are providing emergency services. So in an event of true emergency, you can get an appointment. But from what we're hearing, those are really rarely granted and reserved for humanitarian cases. The US consulates and embassies abroad are also providing services to US citizens. So if you're a US citizen and you're currently abroad, you can still reach out to embassies and consulates abroad for assistance. Although back in March, the Department of State did issue an advisory to all US citizens asking them not to travel internationally at this time. Essentially, it was a level 4 or the highest level advisory recommending to US citizens to avoid any and all global travel. Some of the updates from the US Customs and Border Protection. This is the agency that essentially controls the movement of goods and people into the United States. Just like many other countries around the world, the United States issued a number of travel bans. Primarily, at least to date, Trump administration has suspended the entry into the US of most individuals other than US citizens and lawful permanent residents who were coming from 4 geographic locations. So mainland China, 1, Iran, another 1, Ireland and United Kingdom is the 3rd category, and the 4th category is European countries in the Schengen area. So if you're coming from one of those geographic locations, you're limited from entering the United States in the 14 days preceding the attempted entry. In other words, if you've been to those locations in the 14 days prior to travel, you're not going to be allowed to the United States. United States citizens who are coming from those locations are still allowed to enter the United States, but they have to fly into one of the designated airports that have enhanced entry screening capabilities, and they must also self-quarantine for 14 days after their arrival. Another important development, as I'm sure many of you heard, is that US, Canadian, and Mexican officials have agreed to impose restrictions on non-essential travel at land ports of entry. And again, these temporary border closures contain very broad exceptions for US citizens and lawful permanent residents or green card holders and their family members. What essential travel is? Essential travel is travel for medical purposes, travel to attend educational institutions, travel for work. So if you have a US work visa, you should be permitted to enter. Travel for emergency response and public health purposes, lawful cross-border trade, so commercial truck drivers are permitted to enter the US, and then travel on official government or diplomatic trips. And the like. The rules specify that essential travel does not, again, include travel for tourism purposes. So if you're coming to the United States through land of port of entry to sightsee, for sightseeing purposes, recreation, gambling, or attending cultural events, it's very likely that you will be denied entry. Again, I want to emphasize that temporary workers with otherwise valid visas or statuses should be allowed to cross the border if necessary. It is a good idea for employers to provide such workers with a letter explaining the need for travel. It's a good idea to do that anyways, even in the pre-COVID-19 world, but especially now. And when the border closure was first announced, it was uncertain for some time whether or not CBP would continue to accept new TN and L1 visa applications from Canadian citizens. But many CBP posts have confirmed that yes, they are adjudicating such visa applications at the moment. Either way, it is a good idea to contact the particular port of entry for guidance prior to the trip. A couple of other developments regarding CBP. One is the satisfactory departure relief measure, which is primarily for individuals who are admitted to the United States on the visa waiver program or the ESTA program and who are unable to depart the US prior to the authorized period of admission because of COVID-19. If that happens and the person finds himself or herself unable to leave, they can contact CBP's Deferred Inspection Office and request the so-called satisfactory departure, which essentially, sort of a forgiveness of overstay for a temporary period of 30 days. Finally, I know it's likely relevant to many of you who joined the program. Trusted Traveler Program enrollment centers are currently suspended until, initially it was until May 1st, now it's until June 1st. And this includes Global Entry, Nexus, Sentry, Fast Enrollment locations. Next, I want to talk about some of the developments relating to the Citizenship and Immigration Services. As I mentioned, this is the agency that employers and businesses deal with if they want to sponsor foreign national for certain non-immigrant and immigrant visa categories. USCIS announced at the beginning of the pandemic that it was closing field offices and application support centers for in-person appointments. So right now, all the appointments that were scheduled through June 4th have been canceled. And USCIS is sending cancellation notices to applicants who have previously scheduled appointments and is rescheduling them. Again, the hope is that the in-person processing will resume come early June, but it could be delayed even further. If there are any emergency needs for an appointment, in-person appointment, for example, if you're in the United States and need an emergency advance parole document, which is a document that you need to leave the US and then to be able to come back, you can try contacting the USCIS contact center and request an emergency appointment. Other noteworthy developments from the USCIS is that we no longer have the ability to request expedited processing of visa petitions. The so-called premium processing is suspended for all so-called Form I-129 and I-140 filings. Premium processing guarantees adjudication in 15 days for an additional fee. And while it's expensive, it's a really useful feature and service to have, because oftentimes, because of the timing in the filing or the need to travel or the need to transfer employment sponsorship to a different employer, we would utilize premium processing, and that is no longer available until further notice. On the flip side, the agency is showing some leniency because of COVID-19. It is extending deadlines for responding to requests for evidence or notices of intent to deny, which are oftentimes issued in connection with an immigrant or non-immigrant visa filings. Another measure that we've seen, which has been really helpful, is that the agency is no longer requiring the original signatures on all filings. Now we can use scanned signatures to accompany our filings for immigration benefits, which has really simplified things a great deal, since many of our clients have difficulty accessing post office or having even printers at home to print the necessary forms. The Department of Labor, I'm not going to go into great detail about the developments coming from the Department of Labor, but where it comes into play is that if you're a US employer or you work for a US employer and you are being sponsored for certain temporary or permanent visas, you may need to deal with the Department of Labor, and that Department of Labor certifies, for example, in H-1B context, that the foreign national wage payment obligations meet the statutory standard. So by certifying the so-called labor conditions application, the department essentially says that yes, H-1B petition filing is not gonna adversely impact US workers. In the green card context, if you're being sponsored for a green card, or if you're a US employer and you intend to sponsor somebody for a green card, the Department of Labor essentially certifies, when it comes to certain immigrant visa classifications, that there are no willing, qualified, and able US workers to take the position for which a foreign national is sponsored. So this is the role of the Department of Labor and Immigration processes. So in light of the pandemic, the Department of Labor has announced that it has eased certain requirements with respect to LCA postings, and I have a link here on my slide if it's something relevant to you and you want to read more about it. But the H-1B LCA wage payment obligations still continue to apply during this period. H-1B is one of the primary work visa categories that are used by employers in the United States to sponsor professional workers. And it comes with, as I mentioned, wage payment obligations. So employers should be mindful that if employers considering a layoff or furlough, it has to continue to meet H-1B wage payment obligations. In other words, unlike certain other visa categories, H-1B workers must be paid the promised wage until the employment relationship is terminated or the petition is amended to reflect the new terms and conditions of employment. So again, those obligations are still ongoing. Regarding the green card process, the Department of Labor is now issuing electronic approval materials for certified labor certification applications. They're called PERM applications. So that's been a nice feature. Other actions taken by the Department of Homeland Security in light of the pandemic that are relevant for employers. We have seen, again, more leniency when it comes to Form I-9 completion. Form I-9 is the form used by US employers to verify identity and employment eligibility. And the Department of Homeland Security announced that it will exercise discretion and it will defer the physical presence requirement when it comes to inspecting identity and employment authorization documents. So normally when you hire a worker, you have to physically inspect identity and work authorization documents, and that requirement is temporarily being waived. Finally, for those employers who are enrolled in E-Verify, which is an electronic identity and employment verification system used by some employers in the US, those employers are seeing extended time frame for taking certain actions to resolve the so-called non-confirmations or issues with identity and employment verification. So again, these are some of the leniency measures that federal government agencies have announced. Regarding tips for cross-border travelers and employers when it comes to travel to the United States, if you are planning on going to the US on a work visa or applying for a work visa at the port of entry, I encourage you to plan ahead and act early. Because especially in the current climate that we are seeing, a lot of filings are being scrutinized by CBP and United States Citizenship and Immigration Service. So you want to ensure that you or your workers who are traveling internationally carry complete paperwork, and that you review eligibility requirements for a particular work visa very carefully, including, what it is that the foreign national will be doing in the US, what are the terms and conditions of employment, and do the beneficiaries' qualifications meet the visa requirements. Because as we've seen from President Trump's announcements and other government agency actions, US agencies impacting immigration are taking a more sort of a stricter stand, if you will, when it comes to admitting foreign workers into the US, especially in light of growing unemployment domestically in the US. And we're likely to continue to see those trends in the future. And finally, if you do have foreign national workers in the US currently under work visas, or you yourself have a work visa, our advice is to continue to maintain good compliance practices. If there are any changes to the terms and conditions of employment, it is a good idea to consult with Immigration Counsel on whether or not an amendment to a certain visa filing may be needed. If you have H-1B workers that you are sponsoring for work in the United States, make sure that you maintain good, the so-called LCA compliance files and the like. And of course, we're happy to consult any of you if you have any specific US immigration questions or naturalization questions.
Thank you so much, Eva. And we'll go right into audience questions and ask each of you to respond very briefly. So I think the next question, the first question that I have is for Jay. And for temporary foreign workers currently working on visas or have work visas that are in Canada right now, they're having difficulty obtaining renewals. They have housing and food services that are provided to them. This is really affecting the ability of our hotels to continue business in Surrey and within the Lower Mainland, in British Columbia in general. Can you speak to that a little bit?
Yeah, absolutely. That's a great question, Anita. So a lot of these processes are being affected because, as Minister Mendocino has acknowledged this Monday, I think, he acknowledged a lot of the IRCC, officers are working remotely due to COVID-19 as well, to reduce the pandemic on their part. So it is also causing a bit of backlog in terms of the processing of these extension applications. However, again, this is a quite case-specific scenario that's being asked. It depends on the type of work permits that were held by the foreign workers. For example, if they had work permits that allow them to work in Canada for that specific employer, provided that they have applied for their work permit extension prior to the expiry of their work permits, and they are physically in Canada, then they should have implied status to continue to work according to the conditions and terms of that expired work permit until they get the new work permit in hand. So the legal policy for implied status still continues, and that's why I would encourage them to seek legal advice pertaining to that specific individual's work permits and their abilities to extend their work permits.
So the next question I think is also for you as well. Is there any immigration decisions yet for those who have to wait to complete their working hours, their experience hours, to be eligible for permanent residency because they've had to stop working as a result of COVID-19?
So there's many immigration programs. So immigration is separated into two different categories, temporary and permanent. So I think what the question is referring to is for permanent residents and not temporary. However, I'm assuming that the question is pertaining to express entry for Canadian experience class, which requires that the applicant possesses at least 1 full year of full-time skill work experience. That's at skill level 0A or 0A or B. The requirement is that the experience be gained cumulatively. So even if that person had, for example, 6 months of work that's full-time and skilled, if that person had to stop work, then when they're able to return to work, then they can start gaining the other required 6 months. It's cumulative. Again, this is highly also case specific. I would imagine that it'd be best to seek legal advice to see what other PR programs might be available for the foreign worker in question, and there might be other ways to avail themselves of other pathways to Canada. So I would also highly encourage, I forgot to mention this during my slide, so I was a bit rushed because I wanted to cover as much materials as possible, as you can imagine, but I just wanted to highlight that this is a really good time for businesses to consider, and also for foreign workers as well, to consider what are some pathways to Canada as a PR, because in fact, this IRCC has been issuing draws for invitations recently, and they have been inviting people at the lowest scores recently at lower end of 450s, which is phenomenal. So this is a good time to re-examine, even though things and processes are taking longer. It's a good time to examine from the wide, broader spectrum of things as to what's the best pathway to retain the foreign worker.
So Eva, you may have a perspective on this. Are people still able to apply for the Trusted Traveler programs? Are they able to complete their applications with the enrollment centers, which are closed right now?
So my understanding is that it depends. So if your application requires in-person interview, which many of these programs do require, the way it works, you may be conditionally approved, but the final stage is the interview process. So if that's the process you have to undergo, then at the moment they're not conducting in-person interviews at these enrollment centers, except for what I understand those who are participating in the enrollment on arrival program, meaning that if you're finishing your enrollment in person as you're arriving to the United States at the port of entry. So it's sort of the answer, it depends. Again, if you're not participating in enrollment on arrival program and need an in-person interview, then you have to wait until those enrollment centers are reopened to the public for in-person interviews.
Jay, do you have a perspective on that too?
I don't actually, but I just want to say that these different things, again, like I said, the policies are changing so fast that I would just make sure that before you make any plans, just to check and make sure that you seek the advice, because even boarding the flight might be difficult these days because the air carriers are required to examine passengers and they are required to carry out these exemptions and travel bans. So again, it's good to check in advance before you travel.
Okay. The next question is related to the BCPNP program. And, you know, a perspective is, of course, our restaurant sector has been really hit hard. They've been partially or fully closed due to COVID-19. There's many international graduate students who have completed their studies in British Columbia, then worked on a postgraduate work permit for almost 3 years to gain their Canadian experience. And now for the BCPNP draw, which is basically closed really for them. But we really need to ensure that our economy is thriving. Have you given any consideration, maybe Jay, for you to respond to how these students can be accommodated in regards to the BCPNP program so that the system is fair to them and they can still be economically active in the needed sectors that we have here in Canada?
Well, actually, BCPNP has been quite active in continuing to assess applications, and in fact, it is one of the best provinces in Canada that that really makes its effort, goes out of its way to retain talents in Canada. I mean, I'm an immigration lawyer coming from Ontario, where you have very few programs that are available for students. And for example, graduates and master's program in Ontario opens and then it closes within a couple hours. Unlike that in BCPNP, they really try to attract and retain foreign talents and skilled workers. They, you know, if they're talking about gaining Canadian work experience in BC, I'm assuming that they're probably, again, this is highly case specific, but I would imagine that they are perhaps looking into skilled worker program under BCPNP, which is currently accepting applications. I would just check what the best way is, however, for them to increase their likelihood of getting points. You did mention another really salient point, which is actually something that's affecting a lot of people that are even invited or that are nominees, is that in case of business closures or reductions in hours or anything that has to do with any material changes to the work, that has to be disclosed to BCPNP because that can impact the nomination. BCPNP is fully aware of the pandemic and all these different changes, and they are, again, cognizant. However, they do have to still fulfill the eligibility requirements. People that have completed their education in BC that are postgrads, again, they are in a better place than many other applicants that, you know, that are trying to fulfill their pathway to PR. I would just make sure that you know, they know that there are certain programs that are available, for example, federal programs as well, that they may qualify under, and recommend that they seek independent legal counsel to make sure that they explore all the options.
My last question, possibly also to you, Jay, because we are running out of time. Very active discussion, but so integral because Canada and US are so closely tied together, is how do travel bans affect foreign students who are scheduled to attend post-secondary institutions in Canada?
That's a really good question, Anita. So actually what the government has provided clarification is that people that have study permits that are valid, or people whose study permit applications were approved on or before the travel ban came into place, which is March 18, can still travel to Canada. They do need their valid study permits, or if they were approved before or on March 18th, they just need to bring their study permit approval letter. But in case of their studies, it's important to be mindful of the fact that many of these institutions have now changed their programs to be remote. And in fact, they have changed the requirements for the study permits, because it used to be that you can't attend this distance learning program for being eligible to apply for postgrad. But the government has clarified that they also understand that many of these programs are made into distance learning because of COVID-19, because schools are closed, but they're carrying on their classes online. So the government has made some flexibility in that respect. Again, I think it's important to make sure that they check with an immigration lawyer to make sure that their cases and their specific scenarios fit into that.
Thank you so much, Jay from Fasken And thank you so much to Eva from Dorsey and Whitney from Seattle. Just a wealth of experience from both of those legal firms. You will receive their contact information and a link that will be sent to you with the recording. Remember to check actively the Surrey Pandemic Business Center at businessinsurrey.com. Thank you again to the Port of Vancouver for your sponsorship. We will get back to you for any unanswered questions that we didn't get to today. And remember, we have a digital town hall tomorrow and many upcoming town halls in the forthcoming weeks to help your business. Check out again, businessinsurrey.com.